Good evening. My name is Brian Ashwin John, and today I will be presenting about formalities in land law and discussing the effects that it has in land law transactions, be it good or bad. Firstly, we have to ask the question, what are formalities in land law? Formalities in land law are essentially legal requirements that have been imposed upon certain matters of substance to be codified in specific forms in order to have some legal consequence. In layman's terms, the law basically imposes statutory provisions that has to be followed into land transactions so as to meet the formality requirements which have some form of legal or equitable propriety interests. An example of this can be seen in Section 2 of the Law of Property Act of 1989. In the case of First Coast Homes Limited and Johnson and others of 1995, there had been a dispute between parties as to whether a contract had been made or not. In this case, the proposed contract was contained in a letter and also a plan. However, only the plan had been signed by both parties. The courts had held that the requirements under Section 2 of the LPA 1989 had not been satisfied. This, however, is due to the fact that it had been the letter that contained the contract which referred to the plan and incorporated it, and it was the letter and not the plan following Section 2 of the Act that had to be signed. It was further held that a typed signature is insufficient in a land contract. The introduction of the Law of Property Act of 1925 was introduced in order to solve the problems that had existed prior to this date. It has significantly made transfer of land much simpler. The LPA 1925 was introduced with a group of other legislations with the intention to modernize the law and to render the sale of land as rapid and as simple as the sale of goods. The LPA 1925 can be seen to be complemented by the Law of Property Miscellaneous Provisions Act of 1989, which is an act to make new provisions in regards to deeds and their executions and contracts for the sale or other dispositions of interests in land. The LPA 1925 can be seen to only solve a fragmentation of land and the problems of encumbering the land with third-party interests to the detriment to land transfer. Therefore, it was not the only means whereby the problems were solved. The Land Registration Act of 2002 had also radically simplified the transfer of land. The LRA 2002 essentially lists registrable dispositions whereby third-party interests must be registered as a notice or restriction. A registered interest will constitute actual notice. Interest must be registered, otherwise they will not be binding on a purchaser unless the interest is overriding. Therefore, we can see that these are the current positions of formalities in regards to land. We can note, however, that binding agreements concerning land must, with but few exceptions, be made with due formality. Estoppel, on one hand, is an antidote to the absence of formalities if it would be unconscionable for the landowner to rely on the absence of formality in order to defeat the claimant. Therefore, it can also be regarded as one of the current positions of land law. In order to further evaluate whether the requirement for formalities detracts the autonomy of the landowner in dealing with his or her property, we have to firstly discuss the advantages and disadvantages that is brought upon when there is a need for formalities. Firstly, we have to understand when formalities are present in a contractual agreement, the restrictive statutes in regards to the formation or the transactions of contracts in regards to land detracts the landowner from his personal autonomy as he's unable to transfer propriety interest in accordance to his own style. In the case of HSBC Trust Company, United Kingdom Limited, and Gabriel Brian Quinn of 2007, a written agreement which states that one party would sell a property to another individual at a certain price had not been a deed, and although the language of the agreement and that it had been signed at witness, which indicated that it had been intended to have some form of legal effect, those factors stated did not necessarily point to the fact that the parties had intended that the agreement to be a deed. This proves that formalities are restrictive and detracts from the landowner's personal autonomy. Similarly, in the case of Sharma and Another and Simposh Limited of 2011, the courts had strictly voided the whole agreement due to the fact that it did not necessarily comply with the formal validity that had been set out. This proves that courts are particularly concerned with the facts of validity and formalities, and therefore landowners would experience limitations whereby their personal autonomy are diminished due to these formal requirements. Another issue in regards to formalities would be the costs. According to Critchley, she states formality is something which is added to the basic requirements of the law in relation to a particular transaction. It, therefore, creates a separate obstacle which must be surmounted if we are to enter the transaction. If we manage to get over this obstacle, we will have been put to extra trouble and cost. Therefore, due to the costs that are incurred in regards to formalities, it detracts the autonomy of the landowners in dealing with his or her properties. Individuals would therefore be required to take into consideration the additional costs that is required, which therefore would detract the autonomy of the landowner in dealing with his and or her property. However, to say that formalities diminish personal autonomy to a full extent would be incorrect. There are certain exceptions when it comes to the laws surrounding formalities. For example, a landowner is allowed to issue a lease informally without the presence of a deed as long as it is in accordance with Section 54, subsection 2 of the LPA 1925. These statutes given, which grants exceptions to the general formality requirements, essentially recognizes that people create informal periodic tendencies. The case of Young and Laurentani of 2007 shows the fact that even in situations whereby there is no agreement that can be said to be enforceable due to formality in compliance, courts are ready to examine and evaluate the intentions of the agreement in the first place and give rulings that would uphold justice to the highest point. As stated earlier, formalities controls the behaviors in which landowners deal with his or her properties. It essentially stops them from creating any arrangements which suits their personal needs. Different individuals with different backgrounds, circulating with separate moral, ethical, and also theological views, might view this as detraction of their autonomy. However, to argue against these views, we can view these detraction as they view it as justifiable. This is due to the fact that the act and formalities gives some form of clarity, not to mention sets out a degree of uniformity for landowners, whereby every transaction that is commenced has some form of legal effect. Without formalities, certainties are not necessarily guaranteed. There would be no presence of any form of guidelines and scopes to be met. Formalities essentially work as a legal framework which guards against any form of perplexities or ambiguity. Furthermore, according to Critchley, formalities may be producing a beneficial protective effect where they require or lead to the involvement of legal professions. She argues that the presence of formalities may often lead to the involvement of legal professions. She argues that the presence of formalities may often lead to parties obtaining legal advice, which would in turn allow the lawyers involved to detect and also prevent the application of some form of external pressure. As seen earlier as well, extra costs caused by the formalities essentially cause some form of extra trouble. However, one advantage of this extra trouble would be that it helps warn people or alarm individuals of the significance of the transaction that they are about to enter into. As stated by Critchley, this will basically force parties to stop and think and would also guard against any rash or ill-considered decisions which might be regretted later on. Unfamiliar properties that are present may also aid in ensuring that parties are not entering into some form of transactions that, unbeknown to them, have an effect in law. This would also encourage individuals to find any form of legal advice and obtain help in completion of the required documentation. Therefore, as seen, additional costs may detract the autonomy of landowners to an extent, but it may only be to a limited extent, as it is inevitable that landowners would know that transactions in regards to land are lengthy and costly due to its social importance and financial value. Therefore, additional costs, which causes some form of extra troubles, would be more of an alarm and aids landowners rather than just diminishing the autonomy of landowners. In conclusion, we can see that formalities in a contract of sale of land are extremely significant, especially in being a safeguard for landowners. It, however, may to the slightest part diminish the autonomy that landowners have over their land by controlling the behavior of sale that they have with their land. This, however, may act as an aid rather than a detriment to landowners, as stated earlier. It may be a safeguard and an alarm to landowners in dealing with their land. The issue of autonomy in dealing with his or her land is only on the landowner to be seen as a detriment or a benefit. As it was held by Nelson and Stark, it is our attitude towards those formalities which in the end creates a burdensome tension between private ownership and restrictions upon disposition. Therefore, even though there may be a slight inconvenience due to these formalities, it can bring about a bigger importance by being an aid and safeguard to landowners. Thank you.